Right. Good afternoon, everyone. It's wonderful to be with you. My name is Whittney Barth. I am the Executive Director of the Center for the Study of Religion, Law and Religion at Emory, and I teach classes here at Emory Law School. I'm delighted to be moderating this illustrious panel this afternoon, and I want to start by just thanking the organizers of the symposium, Stephen Heyman and Kathleen Brady, for assembling a wonderful assembly of discussions throughout the day, and especially thanks to the student leaders at the Chicago Kent Law Review as well for all of their hard work and leadership on this occasion. So I will introduce each one of our panelists at the beginning of each of their sessions. They'll have about 15 minutes or so to talk, share with us their papers, and then we will move into Q&A. I will say if you have a question, please enter it into the Q&A feature within Zoom, and I will be monitoring that, and we will get to as many questions as we possibly can. We'll start with Professor Alan Brownstein, who is a professor of law emeritus at the University of California, Davis, and his paper is called Attempting to Protect the Liberty and Equality of Minority Faiths and Non-Religious Individuals When the Supreme Court Will Not Do So. So I'm going to turn it over to Professor Brownstein and also say I'm going to be doing these short introductions by just identifying every speaker's institution. I encourage you to read their bios, which are long and wonderful and illustrious on the website. So Professor Brownstein, without further ado, I'll turn it over to you.
Thank you. And I want to thank Steve and Kathleen for inviting me to participate in this Law Review Symposium. I strongly suspect that this will be the last Law Review article I write. Hold your applause, please. And I'm privileged and honored to be able to complete my formal scholarly career among the very distinguished group of academics who are also presenting papers in this event. Let me be forthright about the purpose of my article. I believe that religion clause decisions are good or correctly decided if they reflect the goals of protecting religious liberty and religious equality as foundational values, without privileging religion as a belief system or the status of particular faiths. From that perspective, I expect the decisions of the current Supreme Court, for the most part, will be bad and incorrect. Accordingly, in my essay, I will discuss some of the possible ways in which these values can be vindicated through political deliberation and/or the actions of private and public actors. I don't have high hopes that many of these suggestions will be followed as a general matter, although they might be implemented in isolation. Put simply, I'm not at all sanguine or optimistic about the prospects of civic friendship, goodwill, and respect for pluralism carrying the day when government involves itself with religion without a constitutional backdrop to rely on. Indeed, I remain somewhat mystified as to why anyone would trust political majorities or government when religion is at issue. And I don't distinguish between free exercise and establishment clause concerns here, although apparently many people do. I think government can't be trusted to adequately respect religious liberty on an ad hoc basis without meaningful free exercise jurisprudence to guide it, and government can't be trusted to respect religious liberty or equality when establishment clause values are at risk. Despite my lack of optimism, I should emphasize here that with regard to continued constitutional litigation, political action, academic scholarship, and cultural engagement, I don't think futility precludes attempts to do what is good and what is right. So what can be done when there is little hope of positive judicial intervention? Given my time constraints, I can only offer brief summaries of possible steps forward here. Proposal 1, create guidelines for the government's involvement with religion. Put simply, discretionary decision-making by government officials is anathema to religious liberty and equality. Consider 2 examples. Public employees should be permitted to engage in religious exercise to some extent during their workday. Public employers can and should reasonably limit employee religious exercise when it interferes with the effective performance of their duties or coerces or harms the public beneficiaries of their work. But that reality standing alone is an inadequate operational rule. It doesn't provide religious employees sufficient guidance as to when their religious conduct is permitted, and it gives supervisors too much discretionary authority to pick and choose what religious activity they will allow. Guidelines limit chilling effects and constrain arbitrary decision-making. Or consider the town of Greece case. Here, the court's acquiescence to over 10 years of alleged carelessness in only inviting Christian clergy to offer prayers at town board meetings deserves derision. While the court's decision forecloses constitutional adjudication of this issue, however, it doesn't preclude political decision-making that respects religious liberty and equality. Town boards don't have to invite clergy to offer prayers before meetings at all. And if they do so, they can provide low-level functionaries tasked with inviting residents to offer prayers with invitational requirements and criteria which will respect religious pluralism and the dignity of minority faiths. Proposal 2, regulatory exemptions and government-sponsored religious messages should be generalized. While the court has made it clear that religion-only accommodations are not per se unconstitutional, it doesn't require that accommodations operate exclusively for religious institutions and individuals. Indeed, the conscientious objector cases convey the contrary message. Thus, when it is reasonable to do so, accommodations should be stated in secular terms and make them applicable to both religious and non-religious individuals and institutions. Doing so reduces the risk of bias and the unnecessary privileging of religion. Let me give you an anecdotal example. I live in Davis, a university town in Yolo County, California. The Jewish population of Yolo County is very small. There's only one synagogue in the entire county, and the overwhelming majority of Jews in Yolo County live in Davis. My community took steps to create a second Jewish section in the Davis Public Cemetery. Cemetery sections are available to any group, religious or otherwise, that can purchase the requisite number of plots to constitute a section. A few members of my synagogue who lived outside of Davis were prohibited from buying plots in the new Jewish section of the Davis Public Cemetery. A state law prohibited the cemetery from selling plots to individuals who lived outside of the public cemetery district. Now, I was co-president of my synagogue at the time, and I asked our representative in the state assembly if she could do anything to assist my congregants. Her staff quickly determined that it was very unlikely that we could get the law repealed. But the proponents of the law did not object to limited exemptions from its application. To its credit, what the legislature enacted was an entirely secular exemption for the Davis Public Cemetery District to allow for the internment of 500 individuals who are not residents of the district. 4 other similarly secular exemptions are in the California Health and Safety Codes. Expressing accommodations in secular terms is often a step in the right direction. However, let me be clear here that I am not suggesting that all religious accommodations must always be generalized to include arguably secular activities. Religion often requires and deserves distinctive treatment. These are situations when generalizing an accommodation can be done without undue cost, as I think my cemetery example demonstrates. When that's available, we should be open to it. State-sponsored religious messages should also be generalized. I believe the best way to promote and protect religious liberty and equality is for the government, as a general matter, to communicate as few religious messages as possible. Religious expression should be the domain of private religious individuals, congregations, and institutions. When government expresses religious messages, its statements are often declaratory of religious truth, implicitly coercive to minorities, or an endorsement of favored faiths and disfavoring of religious minorities. It remains unclear the extent to which the current court will recognize constitutional limits on state religious speech. For the purposes of this essay, let's assume the worst. There will no longer be any constitutional constraints preventing the state from declaring religious truth, promulgating religious doctrine, proselytizing the majority's faith, or endorsing favored faiths. Now, I expect that's what the court was ultimately going to do in the next 5 to 10 years, although it will deny that that's what it's doing. But this doesn't mean that the state is required to engage in such activities. Government can still elect to remain silent on most religious matters. When the government does express religious statements, there are ways it can mitigate, although not eliminate, the likelihood that its messages will be heard and experienced as declaratory of religious truth, proselytizing, or assigning higher status to favored faiths. Probably the most effective way to accomplish these goals is to attempt to generalize the state's message to reflect the pluralism of our communities. And the best example here involves the way our country memorializes our honored dead, service members who are buried in our national cemeteries. While there have been cases adjudicating and upholding standalone crosses at war memorials, more pluralistic memorials should be supported. The National Cemetery Administration, which provides headstones for the decedents in national cemeteries, does not preclude religious messages. Far from it. Nor does it recognize and impose a single icon of only one faith either. Instead, as of last count, it accepts 98 different emblems of belief on headstones, including the diverse icons reflecting the beliefs of Christians, Jews, Muslims, Sikhs, atheists, Wicca, Druze, and Hindus, among many others. I offer this only as an example, but the underlying principle should be clear. The more inclusive the government's religious message, the more it will reflect the religious pluralism of our people, and the less likely it will be understood to communicate a declaration of religious truth, religious proselytizing, or an endorsement of favored faiths. Proposal 3. Religious accommodations that privilege religion or harm third parties should be limited and mitigated. Some religious accommodations provide material benefits to claimants, what I call surplus secular benefits. The current court may be quite comfortable in mandating such privileged treatment, and government has to obey those decisions. But so far, at least, the court has not prohibited government from offsetting these secular benefits. The classic example is the exemption from military service for conscientious objectors. The secular benefit from this exemption is partially offset by the requirement that conscientious objectors must perform non-military alternative service. Offsets in other circumstances may also be a condition of accommodation. The court may also be willing to mandate accommodations that impose costs or harms on third parties. Exemptions from civil rights laws would be an obvious example. Here, the court might take steps to mitigate or spread these costs. For example, the state might provide information to customers and clients denied services, detailing the availability of alternative providers. And in some cases, the state could actually spread costs by assuming an obligation to provide services to those who've been denied access by religious providers. Proposal 4. Several scholars have suggested that the court will not support religious liberty claims that align with regressive values. Claims related to reproductive autonomy, the well-being of immigrants and refugees, and freedom coerced participation in state-sponsored prayer and other religious activities. Here, the stand should grant discretionary accommodation if the court's free exercise jurisprudence is limited by ideological preferences. Proposal 5. Recognize that religious discrimination in hiring and the provision of services by state-funded religious institutions burdens the religious liberty of applicants denied job opportunities or beneficiaries denied services for which they would otherwise be eligible. Accordingly, religious institutions should not discriminate in hiring or the provision of benefits on the basis of religion in state-funded programs unless they are clearly compelled by their faith to do so. Now, I'm Jewish. My son was born in a Catholic hospital. The obstetrician was a Mormon. The executive director of my synagogue hasn't always been Jewish. We should be open to pluralism even within the structure of religious institutions. Proposal 6. Invitations to pray from government officials who have discretionary authority to impose sanctions or to deny benefits to those individuals to whom the invitation to pray is extended are intrinsically coercive and should be constitutionally prohibited. The court's delusional decision in town of Greece rejects this truism, at least for legislative bodies. It remains unclear whether this holding will apply to judges, school teachers, welfare administrators, public employers, and others. Government should prohibit state agents from extending such offers to prey that cannot be safely refused. The open question is whether courts will grant free exercise exemptions from these requirements to state agents who assert a free exercise right to proselytize students, litigants, welfare beneficiaries, employees. I'm going to skip a couple of these because I'm running out of time. Proposal 8. Don't treat new religious minorities moving into the community as guests who must be subordinate to the religious sensibilities of the majority. A previously homogeneous community may have developed cultural traditions over time that reflect the majority's religious beliefs. But when the religious demographics change, respect for tradition should not become a wall of indifference to the needs and interests of new religious minorities moving to a community. A wall that risks becoming a barrier to newcomers of different faiths locating in previously homogeneous areas. Now, when I started out speaking and writing as a church-state scholar over 3 decades ago, I told people that the meaning of the religion clauses had some personal relevance to me. Altar cockers like Chip Lupu and Doug Laycock probably remember me saying this. I explained that the court's understanding of the religion clauses gave me some confidence that I could move around and live and work and raise a family anywhere in the United States, with my rights and equal status as a Jew carried with me throughout our country. I probably carried that confidence further than most in accepting a position at UC Davis, moving to a relatively small university town that didn't have a synagogue or a rabbi yet. What advice would I give religious minorities today in choosing a place to live, given the court's new religion clause jurisprudence? It's not an easy question for me to answer. I continue to believe that racial, religious, and ethnic integration is an invaluable asset to the long-term social fabric of our society. Living and working with people who in various ways are different than you are creates the possibilities of developing bonds of empathy and solidarity. It dispels stereotypes. It allows us to see and understand all that we have in common. Now, I admire and applaud the energy, fortitude, and courage of those who are willing to move into communities where they are and probably always will be a very small religious minority. But can I recommend that to religious minorities today? Probably not. The constitutional shield that I thought minorities would carry with them in public institutions and state-funded organizations has been pierced and substantially withdrawn. To live a life with the security that you, your family, and your children will be treated as if they are of equal worth and deserving of equal respect as members of larger faith communities depends more on political power today and on the ability to create a private infrastructure capable of securing state financial support. Both these conditions are contingent on living in a political community where people of your identity and beliefs represent a sufficiently large part of the population that your interests can't be ignored, and where there are sufficiently large numbers of adherents to sustain private institutions respectful of your faith, which can access public grants or subsidies. Thank you for giving me an extra minute or two in my talk.
Thank you, Professor Brownstein, for sharing with us those remarks. We'll move second to Professor Stephen Heyman, who is Professor of Law at Chicago-Kent College of Law, and his paper is Religious Liberty and the Constitution. Professor Heyman.
Hi, good afternoon, and thank you for sticking with us for so long during the day. I'm going to share my screen here. Can everybody see that? Yeah. Great. Okay. So my paper addresses the longstanding debate over the meaning of the Free Exercise Clause. According to the Smith view, the clause protects the right to hold religious beliefs, but it doesn't protect religious conduct that violates general neutral laws. The alternative view, represented by Sherbert against Werner and Rifra, holds that religious conduct is entitled to an exemption unless the government can show that applying the law to a believer is necessary to promote a compelling interest. And it seems to me the strengths and weaknesses of these two views are obvious. Smith allows the government to enforce laws that protect civil rights and the public good, but it affords little protection to religious conduct. Sherbert does just the opposite. It gives this conduct strong protection, but it might undermine the state's ability to prevent harm. Interestingly, these two views share a common flaw. Each view approaches the problem from a one-sided perspective. Sherbert from the standpoint of religious believers, and Smith from that of the state. To overcome this conflict, I think we need to develop an approach that integrates the two views into a broader theory of religious freedom in the state. This theory would identify the cases in which that freedom should receive strong protection, as well as those in which the state's law should prevail. And in this paper, I make a start on developing such a theory. In the time I have this afternoon, I want to do the following. First, I'll describe the classical view of religious liberty that prevailed during the founding period. Second, I'll talk about how that view should be transformed for our own time. Third, I'll sketch a contemporary theory of religious liberty. Fourth, I want to apply the theory to a few examples. And then finally, I want to say a few words about how this approach can promote common ground between the religious and secular elements in our society. So let's start with the classical view. To understand religious liberty, founding era Americans drew on a variety of sources. Christian thought played a very important role. But when the founding generation drafted their new state and federal constitutions, the view that most deeply informed their efforts was the theory of natural rights, natural law, and natural religion that they found in writers like John Locke. Of course, the concepts of natural rights and natural law are familiar, but what the heck is natural religion? Locke and other writers use this term to refer to what people can know about God and religion through the use of natural reason, rather than through divine revelation like the Bible. And we can discern three main teachings of natural religion. The first was that human beings can use their reason to recognize that everything that exists can be traced back to a divine being who created the world and whom we call God. The second is that human beings should love, obey, and worship God. And the third was that God has established the law of nature, which specifies the duties that individuals owe to him, to themselves, and to other people. These rules are known as the law of nature, and they're also the source of natural rights. The law of nature requires us to respect the inherent rights of other people. One of the most fundamental of these rights is religious liberty. Because religion is founded on reason, individuals have to be free to use their own minds, to search for the truth about religious matters, and to live and worship in accord with the truths that they find. These ideas were central to the American understanding of religious freedom, and I think you can see them very clearly in this provision of the Virginia Declaration of Rights that was drafted by George Mason and James Madison. Here's what it says. Religion, or the duty which we owe to our Creator, can be directed only by reason and conviction, not by force or violence. And therefore, everyone is equally entitled to the free exercise of religion according to the dictates of conscience. And it's the mutual duty of all to practice Christian forbearance, love, and charity towards each other. As this language indicates, most Americans believe that natural and revealed religion were fully compatible with one another. So the idea of natural religion did not imply a rejection of traditional religion, but it did provide the most basic justification for religious freedom. So now let's talk about the bounds of that freedom. The liberty to form your own beliefs was absolute, but the liberty to act on them wasn't. Instead, the same natural law that protected religious freedom also sets limits to it. Believers were not entitled to violate laws that protected the natural, civil, or religious rights of others, or the community's right to the peace. As for other laws, the situation was more complicated. So states sometimes did grant particular exemptions, and we've heard about this earlier today. So for example, they often excused pacifists from military service. But in my view, the historical evidence doesn't show that there was a general right to exemption from laws that conflicted with one's religious beliefs. And of course, we've heard that that's controversial. Instead, I would say that writers who address this notion commonly rejected it. For example, Locke held that the government should treat everybody equally without regard to their religion. On the one hand, that meant that it couldn't discriminate based on people's religious beliefs. But on the other hand, there was no right to an exemption from generally applicable laws. However, this left ample room for religious exercise because the main function of the Lockean state was to protect the public peace and the life, liberty, and property of individuals. And so unless a practice violated those rights, the classic example was child sacrifice, then it would be protected. I believe that this classical view of religious liberty can provide a starting point for developing an approach for our own time. But to do so, it needs to be transformed in several important ways. And let me mention two of them. So first, the classical view held that reason would necessarily lead people to believe in the existence of God and the other principles of natural religion. In the wake of Darwin and modern cosmology, this is obviously no longer true. That doesn't mean that religion can no longer be a reasonable worldview, but it isn't the only reasonable one. So I would argue that the Constitution should be interpreted broadly to protect the freedom to hold and follow not only traditional religious beliefs, but also other deeply held worldviews. And so, for example, if the government grants conscientious objector status to religious pacifists, then it must also exempt those whose objections are grounded in secular conscience. Second, the vast expansion of the modern state that other speakers have referred to means that there are now many situations in which general laws can have the incidental effect of restricting religious practice. For this reason, I believe that we must reformulate the doctrines that protect free exercise if we want to achieve the same structural relationship between religious freedom and the state that the classical view sought to achieve. That is, a structure in which believers are free to practice their religion as long as they don't harm other people or the community itself. So now let's see what a theory like this would look like. The threshold question is whether religious liberty should be regarded as a distinctive right at all, or whether it can be reduced to other rights like free expression. I think the founding generation would have no trouble with this question. They would say that religion involves our relationship with our Creator. On this view, religious freedom obviously is a distinctive right. I believe that we should continue to say that, but I would put the point in broader language. As a recent book puts it, human beings are metaphysical animals. They can't be fully satisfied with what's given, but are driven to inquire into the nature of ultimate reality and how they relate to it. The beliefs that they hold on this subject shape their identities and give ultimate meaning and value to their lives. So the ability to form and to live out those beliefs is the deepest form of human freedom. So now let's talk about what this freedom consists of. In the interest of simplicity, I'm going to use traditional theistic language, but I don't mean to preclude other worldviews. The core of religious liberty is the right to form your own beliefs, and everybody agrees that this right is entitled to absolute protection under the Constitution. In addition to belief, religious exercise also involves various forms of conduct. Following the classical view, this conduct can be divided into three categories: conduct in relation to God, to oneself, and to other people. The most basic form of conduct in relation to God is worship. Worship lies near the core of religion, and any impact that it has on outsiders is typically limited. So for these reasons, I think worship should receive strong protection. The government should be allowed to restrict it only where necessary to protect the rights of other individuals or the public, or to protect the compelling interests of the community. Second, religions often require their followers to engage in certain forms of self-regarding conduct. Many of these relate to the body, such as clothing, religious symbols, dietary laws, and so on. This sort of conduct is deeply personal, and at the same time, it affects other people only indirectly, if at all. So for these reasons, it should also receive strong protection. The third category is conduct that directly affects other people. It seems to me that when you engage in such conduct, you enter into the social realm and should generally be subject to the rules that govern that realm. To begin with, that means that you may not violate laws that protect the rights of others. But I would go further and argue that religious liberty also should not mandate exemptions from positive laws that are adopted to promote social welfare. One way to put this point is in terms of competing duties. Believers belong to two overlapping communities, which sometimes make conflicting claims on them. In situations that involve belief, worship, and personal conduct, the claims of the religious community should generally prevail. But in other situations, the civil community can reasonably decide to treat all its members equally and to hold them to the same rules. Now, that doesn't mean that religious exemptions should never be granted. Even if the state isn't bound to grant an exemption, there are situations in which it can reasonably choose to do so. So, for example, it might decide to exempt the Amish from the normal rules of the road as long as they comply with certain precautions to avoid accidents. But this should be a matter for the legislature to decide by weighing all the relevant factors. In short, I would argue that the problem of religious exemptions is just too complex to be governed by a single principle. Instead, the level of protection should depend on the kind of conduct at issue. Worship and personal conduct should receive strong protection, while conduct that directly affects others should not receive any special protection. I think that this theory combines what's most persuasive in the Sherbert and the Smith positions. It represents a departure from the doctrine of the traditional view, but it would bring about much the same results. To see how this approach would work, let's take a few examples. So let's start with the issue in Smith itself, whether a state can apply its drug laws to punish the use of peyote in a Native American religious ceremony. This is a form of worship, and so it would be entitled to strong protection under my approach. In effect, the state should have to meet strict scrutiny. As Justice Blackmun wrote in dissent, the state had presented no evidence that the religious use of peyote had ever harmed anybody, and there was no reason to believe that granting an exemption would undermine its drug laws. So I think this is actually an easy case for protecting religious liberty. Second, the government obviously does need to be able to restrict religious and other gatherings to protect public health during a deadly pandemic. But those restrictions still need to be narrowly tailored. So, for example, the state of New York wasn't justified in limiting religious gatherings to only 10 people when they took place in an enormous cathedral like this one. Third, while worship should receive strong protection, I would say that's not true of commercial activities like operating a bakery. One of the most basic teachings of the classical view is that religious liberty simply does not give you the right to violate the civil rights of others. Businesses that serve the public can properly be made to comply with laws that ban discrimination on grounds like race, religion, and sexual orientation. The Masterpiece Cake Shop decision contains some language like this, although the majority ruled for the baker on other grounds, as Mark told us this morning. Finally, while the state may prevent believers from injuring others, it usually doesn't have any good reason to prevent them from benefiting others. Many religions call on their members to engage in acts of charity and service. Those acts should also receive strong protection. On those grounds, I would say the government shouldn't be allowed to punish humanitarian workers for providing food, water, and shelter to people who are in dire need, regardless of their immigration status. In conclusion, I think I'm just about on target on time. Let me mention some of the ways that this approach seeks to promote common ground between the religious and secular elements in our society. At the most basic level, this approach calls for mutual recognition and respect between the different groups. We have to treat one another as free and equal persons who have the same inherent dignity and rights. Second, the theory seeks to protect the rights and interests that are most highly valued by each group. On one side, it would assure believers that the state may never restrict their freedom of belief, and that their freedoms to engage in worship, personal conduct, and service may be restricted only for compelling reasons. On the other side, the theory would empower the state to secure the civil rights of all its members and to promote the health, safety, and welfare of the community. And finally, the theory would hold that the Constitution's protections, as I said, are not limited to traditional religious beliefs, but extend to all deeply held worldviews, including those that are secular in character. In all these ways, the approach aims to make it possible for people with sharply different beliefs to live together in a liberal democratic society. Thanks very much.
Thank you very much, Professor Heyman. And now our final paper for this afternoon will be Professor Andrew Koppelman, who is John Paul Stevens Professor of Law at Northwestern Pritzker School of Law and Professor by courtesy of Political Science and affiliated faculty of the Department of Philosophy at Northwestern. And his paper will be The Supreme Court's Gay Rights, Religious Liberty Contortions. Professor Koppelman.
Thanks. I'm very happy to be here. Before I say anything else, I should say that it is enormous news that Alan Brownstein says that this is going to be his last paper. I've seen Alan at multiple conferences. He is a great scholar, and I have never read a paper by him that did not enormously impress me. So I'm just, I hope that Alan finds it in himself to do more in the future. But if this is it, Alan, it has been great being in the profession with you. It is one of the privileges of this line of work to get to know
Thank you, Andy.
people like Alan. Just about so. This paper is about a series of cases that I think has rendered the law in this area deeply incoherent. And I'm just trying to understand what has happened here to make the law the mess that it has been. A number of people have talked about the diversity and the clash of religion and secularism in contemporary society. I just read a very good book by Professor Kunal Parker on the turn to process, which traces the way in which there's been a movement toward process-based thinking, not just in law and the legal process approach to law, but also in economics and in the theory of democracy. And in each case, it's because people no longer share views about natural law or just price or what is the true will of the people, and they turn to procedure as a way of coping with this new state of affairs. This means that it is more important than it has been in the past to be really scrupulous about following the rules, because following the rules are what we now have. And if there's going to be common ground, the common ground has got to consist in following the rules. And so when the Supreme Court abuses its rules, this is very big and distressing news. So here's the pattern that I describe in the paper. And I should say for people who aren't participants, I've posted an earlier version of this paper on SSRN, but there is a follow-up version that is coming because there have been big developments in the Scardina case in Colorado, and I'm still hammering out the last bit of that, and it will be on SSRN by and by. So here's what happens. Somewhere in the United States, some conservative religious person or organization refuses to provide some services to LGBT people and runs afoul of some anti-discrimination law. And if that person looks sympathetic, advocates for the religious right massively publicize the story. And then the religious claimant loses at trial, the Supreme Court agrees to hear the case, and the press describes it as likely to produce a major innovation in doctrine, and there's oral argument and everyone is watching. There's national attention to the case, and then the Supreme Court gets rid of the case in a case that lets the religious claimant win, but establishes no clear doctrine at all. The court will misconstrue the record, or it will misrepresent the challenged state law, or both. It will invent a new doctrinal rule that is so extreme or obscure that it can't possibly be applied consistently by lower courts. It sometimes scolds the lower court for failing to anticipate it. And this happens again and again. And so here's the puzzle. Why does the court keep doing this? It has an established tool for disposing of cases that, when they're closely examined, turn out to be poor vehicles for clarifying the law. I mean, that's the way in which they normally exercise the passage virtues that Mark Movsesian was talking about this morning. It can dismiss a case as improvidently granted. It does so a few times each term. The court's job is to resolve large uncertainties about the law, not to supervise and correct trial court's conduct of individual cases. That kind of retail work is the job of the lower appellate courts. This is why the Supreme Court has the control over its jurisdiction that it got in the Act of 1925. So here's a hypothesis. In each of these cases, the majority can't stand to uphold the lower court's decision against the claimant, which is what the effect of a dismissal would be. But it can't converge on any coherent rationale for a reversal, and so it twists case-specific details, it fashions opaque new rules to get the result that it likes. Now, in the time I've got, I can't talk about all of the cases involved. The paper talks about Boy Scouts versus Dale, Masterpiece Cake Shop versus Colorado, Fulton versus Philadelphia, and 303 Creative versus Alanus, and then concludes by talking about the distortions of the law reflected in a fifth case that is not in the Supreme Court, Scardina versus Masterpiece, in which the Colorado Supreme Court deployed a novel, bizarre procedural maneuver in a way that kept the U.S. Supreme Court away from yet another opportunity to make mischief, indicating that I think that the lower courts are frightened of the U.S. Supreme Court because they think that the U.S. Supreme Court is going to introduce chaos into the law. Now, this pattern of evasion arises, I think, from two difficulties that are characteristic of all religious exemption cases. First of all, a court has to worry about opening the floodgates to so many claims that the underlying statute's purposes will be defeated. This is a concern that the court has never formalized, but it is always on the mind of the court. You could see it in the passage that Steve Heyman just quoted, where the court said, well, there's not really a very big market in peyote in the United States. If there were, then that might change the result. And it's not clear then what the court would do if, after the decision, lots of people joined the church because they wanted to use peyote. What would happen? So this is a problem. This is generally the case when the religious claim is for a benefit with secular value. And in all discrimination cases, a judgment for the defendant in advance of trial has secular value for that defendant. And then the finding of a religiously based right to accommodation, or even a finding that the claimant has been discriminated against, triggers the compelling interest test. And the court has been trying to avoid deciding whether preventing anti-gay discrimination is a compelling interest. The problem is that if it decided that such an interest was not compelling, that would clearly have no basis in the law and would only reflect the judge's own controversial political predilections. And the judges know this. And so both problems are avoided when it hands down a decision of Delphic obscurity. And together, these cases suggest to me that however America addresses the gay rights religious liberty conflict, the courts do not have the right tools for the job. Any resolution that comes from them is going to be too crude to do what needs to be done to devise an account of American political identity that has a legitimate place in it for each of the tribes that hold deeply contradictory views about the ethics of sexuality. The best courts can do is nudge legislatures in the direction of compromise. Well, so I have a problem orally deliberating the paper because quite a lot of what I do in the paper is make persnickety objections to detail in each one of these cases and argue that the cases are abusing the procedural constraints on the court. But I'll notice, so I'll just going to briefly talk about a couple of these cases. A number of people at this conference have talked about the Masterpiece Cake Shop case, where the couple asked a baker to make a cake for their wedding, same-sex couple. The baker refused. He appealed the decision on grounds of freedom of speech and freedom of religion. It was very hard to make that argument work in any coherent way. A number of such arguments were tried. The court ended up disposing of the case by saying, well, there was somebody at the hearing who said things that the court thought was indicated hostility toward religion. It's a very odd holding because the claim is that the claimants who had been injured and had an action against the bakery lost their action against the bakery because of actions of third parties, in this case commissioners, who they could not control. The court reproached the commission for allowing the commissioners to make the statements, which Micah Schwartzman and Leslie Kendrick have shown really were not particularly prejudiced against the defendant. But even if they were, the court said, well, the other commissioners had some duty to disavow them. No objection was made. This was an objection that was not preserved. The commission had no opportunity to purge itself of whatever prejudice there was. There was no motion for the individual commissioners to recuse. And so what happens in the case is that the claimants, who once again under Colorado law had a cause of action with monetary value, were deprived of that cause of action without due process. The court just dismissed with prejudice. And it's so very hard to figure out what are the rules. If one member of a multi-member body shows what a appellate court can creatively construe to be evidence of bias, the defendant doesn't have any objection to object, even though he has to preserve all of his other claims. The other members are obligated sua sponte to repudiate the alleged bias, and then there's nothing the plaintiff can do to rescue his claim. If they don't do that, it'll be dismissed on appeal regardless of the merits. It just can't possibly be the law. In the very limited time I've got left, I'll also talk about 303 Creative, where a web designer claimed that she was going to refuse service to a same-sex couple if they asked for service from her hypothetical website. The whole case was hypothetical. The court said that website design was pure speech that could not be compelled. How does he know that the website is pure speech? The court says that, well, there are facts that are stipulated. The websites will contain images, words, symbols, and other modes of expression. Each website will be original and customized, and the websites will communicate ideas, and they'll involve Smith's own speech. Those factors are present in lots of things that the state now regulates, such as an incompetently drafted opinion letter by a lawyer, or a doctor's advice that produces harm to the patient. Presumably, Gorsuch did not mean to constitutionally bar the torts of attorney malpractice or medical malpractice, or failure to warn. Disclosure requirements are ubiquitous in the law, and they involve pure speech. They don't involve conduct. And so we have a rule here that the court can't possibly mean. There is some new exception to United States versus O'Brien, but its dimensions are entirely mysterious. And the court also says some reckless stuff about anti-discrimination law more generally, that eliminating ideas is the very purpose of anti-discrimination law. Well, if that is right, then all anti-discrimination laws are unconstitutional in all of their applications, because an impermissible purpose voids all applications of a statute, including purposes that could be pursued by a statute that had a permissible purpose. So hard to know what to say about all of this, except that the court is it does make life interesting for trying to teach the law in this area, because the law of religious liberty and in this area, the law of free speech is in complete chaos. I will end by saying, how I go about teaching this stuff. We try to walk through the opinions. We try to figure out what the bits and fragments of debris are that are littering the landscape. And then I give the students an exam at the end of the semester where I give them a fact pattern and I say, write the brief on one side and write the brief on the other side, because there's no law here. And so you're going to succeed. In any litigation, I confidently predict somebody's going to win and somebody's going to lose. So, and where the law is chaos, who is going to win and who is going to lose is likely to depend on who has the better lawyer and can make the more persuasive argument. And since as law teachers, we are trying to train people to be able to make persuasive arguments, this is the job that I am eager to hear a more charitable interpretation of what the court has done in these areas. I focus on these two cases because they've been the object of discussion of other conferees, but there is plenty more evidence of the chaos that I just have not had time to go into here.
Thank you, Professor Koppelman. All right. Well, let's move on to our Q&A discussion. And I know we've got a couple of questions already in the queue, but one of the things I wanted to start with, just to give you, well, first of all, one of the kind of themes that I hear coming up in the papers is kind of in light of the Supreme Court's recent jurisprudence, sort of what can happen at a level kind of below the Supreme Court, at local level, state levels. And Professor Brownstein, you gave many good examples of potential ways in which this people might be able to kind of carve out some metes and bounds for some of these questions in ways that try to make sense of where we are. And I wanted to give everyone an opportunity, the rest of the panel, to kind of respond maybe to some of those proposals, or to maybe pick up that theme from the other papers as well. But I just want to give you a chance to respond to each other. And that's one theme that kind of stuck out for me.
One thing about the proposal that the authorities keep a record of what they have been up to, this is a proposal that once would have imposed burdensome record-keeping requirements on public officials, but in the age of artificial intelligence, it is essentially free to do that. So it occurred to me that Alan's proposal is more feasible now than it would have been 20 years ago. And so therefore, there is some burden on someone who decides not to do it after it's been suggested to them.
Mm-hmm.
I like Alan's proposals very much because of their emphasis on a desire to promote common ground, and to not encourage groups to kind of push their positions to the hilt, and to try to defeat or to dominate other groups, but to work out good faith compromises that people can live with as much as possible. And I think there's some reason to believe that the American people in general are kind of more inclined towards that than you would think from just looking at our political life, or from some of the culture war battles that we have in the courts. So I know that Professor Brownstein didn't say that he was particularly optimistic, but I think if there is a path towards trying to have some kind of healing and compromise along those lines, it would probably look a lot like what he's proposing.
Would you like to respond, Professor Brownstein?
Well, I mean, I'm pleased that both Andy and Steve found something of value in my proposals. It's unclear to me whether many of my proposals have much possibility of being accepted. Part of it is my concern is that although we recognize our nation to be a pluralistic society of many different faiths, on the ground, that's not true. There are an enormous number of communities which are entirely homogeneous, where there's virtually no one who lives in the community who isn't a Christian. And the fact that there isn't a culture war issue, a religiously based culture war issue in those communities, is grounded on homogeneity, not a willingness to work out compromises with people who disagree with you. My experience has been that when there is demographic change, when people of other faiths move into a previously homogeneous community, that they are not welcomed. Because their presence requires a reevaluation of traditions that were never considered to be problematic because there was nobody to be offended, nobody who felt that they were excluded by the tradition. But once that happens, once there are people who say, wait a minute, what about me? What about my community? I don't see a reservoir of civic virtue and goodwill helping to resolve those difficulties, which is why I concluded by saying, if I had to recommend to someone of a minority faith where they would choose to live, well, I understand where you live depends on a lot of things, your job, your housing, healthcare, family, but to the extent your status as a member of a religious minority as part of that calculation, I would not move to a community where I was going to be an obvious minority because I would not expect my family or my children to be treated with respect.
We do have one question from the audience. This is for Andy Koppelman, and it's from Mark Movsesian. Is it possible to see cases like Masterpiece Cake Shop and 303 Creative as doing what you say courts should do, namely nudge things in society in the direction of compromise? Precisely because decisions will not be so clear, society has to work it out for themselves. That was a question.
I guess I'd need to hear more about how these decisions are nudges rather than unexplained decisions in favor of people who the judges like. I'll have a clearer sense of what the overall shape of the law is if at some point in the future, some conservative Christian religious claimant loses a case on the merits in the Supreme Court. It has been a long time since that happened. It is hard for me to anticipate anything in the docket where it's likely to happen. And if the general tenor of the law is conservative Christians always win, we will twist the law, we will twist the facts in order to make them win, that does not seem to me conducive to compromise.
Could I just add something to that? So I don't have a way to explain the court's decisions to make them more palatable. I may have a way to make them more nefarious. And that is, it's kind of like the story of how you boil a frog. You don't throw the frog into the pot of boiling water because it's going to jump out right away, exposed to the heat. You put it in a pot of very lukewarm water and you slowly raise up the heat. So to the extent that what the court is doing here is incrementally setting the groundwork for broader decisions, it's not quite ready to go there yet, but it's laying the groundwork of saying, well, the baker won, the printer won, we have this precedent which is respectful of religious liberty claims that arguably impose burdens on the LGBTQ community. Maybe that's a way of building up a judicial record and precedent for broader-based decisions, which do what you say the court is very reluctant to do, which is to conclude that the rights of the gay and lesbian community are less deserving of protection than other minorities in our society.
I wouldn't say that this, I don't offer this as a defense of the court. I think we have to remember that the court is not an it, it's a they, and that there are 9 of them. And that, at this point, the conservative justices on the court, they have the votes to do a lot of things that they've been wanting to do for a long time. And Dobbs is kind of exhibit A about that. In Fulton, just a few years ago, I mean, they had the opportunity to overrule Smith, to reinstate strict scrutiny. And it was Justices Barrett and Kavanaugh that kind of put the brakes on, and Chief Justice Roberts, who decided that they didn't want to go that far. And I think it's partly a matter of actually there not being a consensus on the court, even among the more conservative justices. And I was particularly struck by the fact that Barrett, took that position, because certainly when she was nominated, people sort of had the sense that she was sort of very strongly committed to religious liberty. But she sounded in some ways more like Justice O'Connor in her concurring opinion in Fulton, where she said, she said, I don't like the categorical approach of Smith, but I don't want to sort of, rush from that to another categorical approach that would be equally kind of rigid. And she pointed to all kinds of kind of contextual issues and other factors that she thought needed to really be thought through. So I think that there's some evidence for thoughtfulness on the court at the same time that there's all the evidence that Andy and Alan are pointing to of sort of maybe misuse of these cases.
We have a participant by the last name of Smith. Is that Stephen Smith? You can ask a question to Alan. Go ahead. If you unmute yourself.
Okay, yeah, Alan, it is me.
Okay.
Hi,
Um,
Hi,
Steve.
Steve.
howdy. Um, First of all, like Andy, I was, I don't know, sobering to hear you say that this might be your last presentation, and I hope it's not true. But if it's true, it's been really a privilege to work with you from time to time and these sorts of things over the years. I can't think of almost anybody, I think, probably for whom I have more respect, as a person and an honest scholar and so on.
Thank
You and
you,
I,
Steve.
and I mean, as you know, you and I don't always agree about everything, and uh, so I wanted to just see what you think about this, because when I hear a lot of your work, but like especially your paper today, which was your presentation and your paper that you gave us a couple weeks ago or so, which was as usual just really thoughtful and good-hearted, and and everything. And I always think, yeah, I mean, I just admire that, but I often tend to think that the one thing that makes it difficult for me to just say, yes, yes, I agree with all of that, is that I think you have a view that's consistent with basically the Supreme Court's jurisprudence of the last, part of the 20th century and so forth, which is that religion is inherently a private thing. And therefore, if the state could just leave it in the private sphere, everybody ought to be able to get along. And so people who want to have things like prayer at a public event or something like that are basically just taking something that's inherently private and trying to impose it on everybody else, and that makes things difficult. And that can be true, but I actually think that it's clear that through our history there have been many, many people, and not just sort of like religious fundamentalists or anything, but people like George Washington, I quote in my paper and so forth, say it's the duty of nations to acknowledge God, and solicit his blessings and so forth. That's been, I think, just a pervasive position. And many people, I think, sincerely hold that as a religious matter. And so if they do, it just seems to me like it's a much harder problem than to just say, just leave religion in the private sphere and it will do okay. And I don't think it might even lead you to a slightly more sympathetic view of the current Supreme Court if you think what they are doing is they're seeing that this private religious paradigm just is not shared by many, many Americans, and it's not mandated in any way by our history and tradition. And what do we do now? And I don't think they have any good idea. What do we do now? And it's a really hard thing to figure out what we should do now. But would that, am I right about that? And could that sort of, I don't know, temper your positions just a little bit?
I mean, I respect what you say a lot. I recognize that we are a religious people. And, as Chip Lupu and Bob Tuttle say, secular government religious people. I do think that religion pervades American society. I mean, there are tens of thousands of religious congregations in the United States. Almost all of them have houses of worship. Almost all of them have messages and icons on those houses of worship. You cannot drive anywhere in the United States without feeling that you're exposed to a variety of different religious messages. But I do understand that people want to have more of a, when I say public, I don't mean public-private as like hidden and open. I mean public sector versus private sector. Mm-hmm. And they want more of a public sector acknowledgement of the role of religion in society. And while that's not my particular perspective, because I think it's so subject to abuse, I do suggest ways to make that more palatable, less likely to be examples of bias or proselytizing. So one example, which I didn't, I mentioned it in a paper, but I didn't have time to talk about it in my talk, is the distinction I make between I prayers and we prayers. And I think an I prayer expressed by a member of the clergy at a town board meeting is a very public prayer, but the clergy member who offers that prayer isn't purporting to speak for me or for people in the community of different faiths. If it's a we prayer, the individual is saying, we all agree that this is a acceptable way to communicate with God. And if the prayer ends in the name of Jesus, well, that's not an acceptable way for me to communicate with God. And I don't see why the government should think it has the vested authority to speak to God in my name. Similarly, the more pluralistic the government's expression of religion, the less likely it is to be misinterpreted as declaring a religious truth or proselytizing. And I just think it's preposterous to suggest that in a 10 or 15-year period, you could attribute the fact that only Christian clergy were invited to the town of Greece to offer prayers to carelessness and negligence on the part of the low-level functionaries who invited the clergy. Then nobody noticed that something with the potential of being understood as bias was going on. And finally, you can have public acknowledgments of religion that aren't expressed by people who have the discretionary authority to impose penalties or to provide benefits to people who, as I put it, are given an offer they can't refuse. They're invited to join in a prayer with a recognition that they will be alienating someone in a position of power who may impose a penalty on them or deny them a benefit, and they are going to feel coerced. Now, you could have a public acknowledgement of religion without imposing all of those risks on society. And my question is, why not choose those alternatives if indeed what we're simply trying to do is to acknowledge that people take religion seriously and that they feel like we as a community should make it clear that a lot of us take religion seriously.
Okay, we have two questions in the queue, and I want to make sure that we get to them. So if we could, yes, Thomas Berg, you may ask a question of Andy. Can I ask you to keep it brief? And Andy, please keep your response.
I'm sorry, did I go too long?
No, not at all. I'm mindful of the time. We're running out of our time together. But thank you all for your discussion so far. You're doing fine. But go ahead, Thomas.
Quickly, Andy, the idea that anti-discrimination laws to have the purpose of suppressing speech, I agree, is nonsense, or the purpose of suppressing ideas. However, we did hear that articulated this morning, that it was an essential part of the anti-discrimination laws to do away with discriminatory ideas. And I don't think that view is non-existent. That's more of a comment than a question. I guess my question for you is, do you think, so setting aside that sort of nonsense statement, so much of 303 Creative turned on the stipulations that the state unaccountably made that this was in fact speech, that it was essential that the wedding website was custom designed and would be very much the speech of Lori Smith. That there were, and this seems quite plausible, that there were hundreds of other designers available who you could see online, because these are, after all, website designers. It's not even having to go like 2 blocks over to another bakery or whatever. And I think back to another case in which a very irritating stipulation was seized on by the court, and that is CLS versus Martinez, in which the Christian Legal Society was told that it could not require its leaders to be Christians, because there was a stipulation in litigation that the law school had a so-called all-comers policy, which it turns out in subsequent litigation, no school ever applies a policy like that consistently. And so it was an utterly unrealistic stipulation on which Justice Ginsburg seized to decide the case against CLS. Okay, I guess that's sort of, tit for tat, but didn't the stipulation play a huge role in 303 creative, and aren't we stuck with that? Can I very quickly say, Alan, bravo, thank you. It's been a pleasure to work with you, and on one occasion to write with you, and that was a great experience for me, and it's always been wonderful to learn from you.
Thank you, Tom.
So on whether the purpose of anti-discrimination law is to change culture, my first book actually makes that claim, that one of the purpose, anti-discrimination law and social equality, 1996. I'm not as old as Alan, but I'm up there. It is possible to do that without infringing on free speech. And so it does not follow that the very purpose of anti-discrimination law is to suppress ideas. And that leap that the Supreme Court made is surprising. It is also surprising, I think, to think that the stipulations in 303 Creative mean that there is suppression of speech. You can make the same stipulation about medical malpractice. It is the doctor's own speech, and it's done with words and blah, 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 blah. And so I think that the parties that state in 303 Creative was, I think, correctly surprised to learn that what it is stipulated, which is entirely innocuous stipulations, had this legal effect. That was new news. That was not something that they could have anticipated on the basis of existing law.
We have one last question, and it's from a participant. It's Rick's iPhone. I want to guess who this might be, but I'll just read it unless Rick wants to say
Rick
his
Garnett
question.
would be my guest.
That I'm guessing it's Rick Garnett, but he could let us know if that's not correct. I'll read the question. This panel's casual dismissal of the court's good faith is, to me, disappointing and unwarranted. A specific question, though, for Steve. What is the conservative position on free exercise / Smith? And conservative is in quotation marks. So I'll turn that first to Steve.
Oh, well, that's a fascinating question. In 1990, when Smith was decided, it was the conservative justices in the majority, and then it was mostly liberal justices who were in dissent. And maybe that's part of what the questioner is referring to. It is very interesting that over the 35 years since Smith was decided, that I think what one would generally identify as being the conservative position on free exercise has shifted 180 degrees, and instead of the Smith position that there is no right to religious exemptions, instead conservative justices and scholars very often do argue that there should be kind of strong protections for religious liberty, and to tie it to the the theme of this conference, I mean, my own hypothesis is that a lot of the explanation for that has to do with the culture wars that we've been sort of fighting over the past several decades. So that when the court decided Smith in 1990, they were kind of mostly thinking about religious liberty claims as being asserted by, sort of very small minority faiths or religions like the Native Americans in that case, and that over the course of the past several decades, it has come to be more and more the case that these claims are being asserted by conservative Christians, and that those justices, are becoming more sympathetic to those kinds of claims. But I guess I want to say at the same time that I'm not a culture warrior, and I don't want to come across as dissing any particular group. And on the contrary, I'm very much temperamentally and intellectually committed to this idea of trying to promote common ground. And part of, I would say the main point of my own paper was precisely to try to come up with some kind of doctrinal framework that would protect religious liberty in those situations where the claims seem to be strongest, and also to protect civil rights in cases where they might be endangered.
Could I just add one quick point? Go
ahead, Alan.
Very brief comments, but we're at time, but go ahead.
Okay, I just want to say, as Rick knows, I spent virtually my entire scholarly career and career as an advocate, supporting and promoting free exercise rights. So maybe my disappointment with the way the court has been handling some of these cases says something more about the court than it does about me.
So I tell my students that you are entitled to be a legal realist if and only if you cannot come up with an account of what the court is doing that is consistent with existing law. And you have to do that work and try to, figure out, what is a charitable statement of what the court is doing? Well, I just find it very hard. I'm not directly impugning their good faith, but a masterpiece. So if we offer as a general proposition that the defendant in a suit can raise on appeal an issue that he did not raise at trial, and that it was not even an error that the plaintiff made or that the judge made. It was something that nobody could have anticipated and it was an error. If the plaintiff did see that it was an error, the plaintiff couldn't have stopped it. And on that basis, the plaintiff's claim is going to be dismissed with prejudice. He's just going to lose his claim because of what some third party did. I just can't come up with a charitable explanation of that. It's just flatly violates due process. So, these are really just persnickety lawyers' objections. It's not about what's in the hearts of the judges. It could be that they are just making mistakes. On the other hand, I worked once for an employer who routinely made mathematical errors in calculating my pay, but the errors were all in one direction. And that's what we have here. All I have is the numbers, but the numbers seemed to be eloquent.
Okay. Well, we have more questions, but I think we'll have to cut it off there. Thank you all so much for your papers and for your engagement with each other and with these questions from the participants. And thank you to the participants for your engagement with the panel. And I will now turn it over to Stephen Heyman.
So Kathleen and I started working with the law review editors about a year ago on this project, and we've been looking forward to it for such a long time. And I know I speak for all of us in saying that today's conference has surpassed our wildest dreams for this event. I want to thank everybody involved. I want to thank the moderators and the speakers for the really wonderful and illuminating papers and the discussion. Want to thank the law review members for all the incredibly hard work that they put into this for at least the last 6 months. I want to thank Sue Jaden and especially Emily Barney for somehow managing to bring off a Zoom conference like this with absolutely flawless technological functioning. And I can't tell you how much sleep that I've lost kind of worrying about this, but it all went like a charm. And Emily, thank you so much. And finally, I want to thank all of you all in the audience for spending your day with us and talking about these really important and urgent issues.